to a meeting of the Baltimore City Board of Licensing for Towing Services. We are glad to have you here, especially since this is a rescheduling. Members, please turn on your cameras if you are able to. We will be recording this meeting. And today's meeting topics may involve or result in disclosure of privileged financial or medical information. As a reminder, today's meeting will involve official business of the board, including permitting and oversight. Members of the public not being addressed by the board may not participate in these proceedings, nor may request information from those being addressed by the board. Okay, members of the public will be given a chance to comment after board proceedings have concluded. In attendance today is myself again, the chair for the board. 1 second. I'm sorry. Yes. So the members in attendance today are myself, Lieutenant Charles James for the police, Ms. Carla Neely of finance, and Councilman Antonio Glover. Again, Mr. Glover, congratulations. If we haven't said so in the past.
Thank you. Thank you.
Yeah. Additionally, we are joined by Mr. Luciano Diaz, our policy analyst, Mr. Michael Brady, our claims investigator, and Mr. Christian McNeil, our legislative liaison. And we have reached a quorum, so we'll get started. So the first discussion and vote will be the postponing of the 2025 permit renewal vote. So in our first order of business, we're going to address the discrepancies found in trespass towing applications for the year 2020-25. And these discrepancies concern only vehicles under 10,000 pounds. Now, all references to time begin after the vehicle is made available for recovery. That's important to note. Additionally, these recommendations are based on trespass towing law, not impound law. And based on the law department's advice, I'd like to propose a 45-day extension to the 2024 permits for the following reasons. Just hear me out. Trespass towers can charge a $280 towing fee, which is double the local jurisdiction's rate of $140. Applicants must provide a 12-hour grace period before charging a storage fee of up to $50 per day. This is currently not reflected in towing fee schedules. This is partially on us. Applicants cannot charge additional fees which are not provided by the board, except for a fee to cover the costs of providing notice. And the fee schedule form used as part of trespass towing applications is inconsistent with state law. Due to this discrepancy, all applications are technically non-compliant and should not be approved by the board. So as part of the extension, DOT will provide a revised fee schedule that cites state and city law, reflects allowed and maximum charges, and reflects the 12-hour grace period. A 45-day extension to the 2024 permits would give applicants the opportunity to resubmit their fee schedules to become compliant and acknowledge the 12-hour grace period. So with that said, I'll open the floor for the board members to weigh in. We can start with Mr. James. Any questions or comments about the statements I just mentioned? Oh, he's okay. He says his I think he said his audio is not working. Did I see that right?
His audio isn't working. Well, that's what he put in the chat.
Okay. Well, I guess he can place any thoughts in the chat as well. We'll move on to Miss Neely.
No comments.
All right. Councilman Glover.
No comments at this time.
Okay. Let me check the. Let me make sure I check the chat to see if Lieutenant James has anything. Having trouble pulling up my information. Okay. All right. Well, I'm not seeing anything from Lieutenant James. So what I'll do is I move to vote on this matter. Do I have a second?
So moved.
All right.
Second.
All right. So we're voting. Yes from myself. Other members?
You want to do a call? You want to do it like how you call? You got to call like you want to call out the members of
I'm
the.
sorry.
Hmm?
Lieutenant James, we're voting. I guess you'll have to say yea or nay in the chat. Mr. Lieutenant, if you can, please say. I'm not sure if he's.
You
Yes.
said
Okay.
no
No
comment
comment. But
for the vote.
yeah, we're on the voting at this point, Mr. James. Yeah. So
Mr.
I guess.
McClaren, I think that if he's on the actual chat, I think this is good enough because if he log out and log back in, I mean, we're having this meeting. He may be off or something. I mean, we can just get his yes or no vote in the chat. I think that'd be good for us.
Yeah, that'll
Okay.
It'd
suffice.
still be a record.
Oops.
I don't know. Is he still active? Uh, we need his response. Mr. James, are you still there? If if so, please respond yes in favor or no.
We could come back to him. I mean, if we go to vote, I mean, if that's
Okay.
suitable for you guys. I mean,
Okay, so he has responded.
yes.
Okay. All others in favor, please say yay or nay.
Yay.
So Miss Neely, you saying yes?
Yes.
Okay. Myself, I'm saying yes as well. Only. I think we go in line with names, whatever, just so we reflect on the record, as opposed to just somebody blurting out, yes or no or
Okay.
things like that. So, thanks.
Do you want us to put it in the chat?
No, that's not necessary. If you can speak, that's
Okay. Okay.
all right. Yeah, so I think so that concludes our discussion. Uh, the the vote passes. So the current applications will be extended for 45 days from today. Again, all applicants will receive a revised fee schedule, and the expectation is that the applicants will resubmit. Right. moving on.
And I think
Discussion.
I'm
What's
sorry,
that?
go ahead. I was just saying, I know Mr. Parrish had his hand up. I think he had a question also.
I was going to wait till the end, but I guess we can accept questions for this particular matter right now. Was that Mr. Parrish? You said.
Mr. Parrish, you gotta unmute your microphone.
I got it. So I couldn't find the button. Sorry about that. Good day to everybody. So what I'm understanding, just so I understand, you're extending the license because the application is void because the law department has determined that the maximum fee allowable is $280.
That in combination with a couple of other things that doesn't one being it doesn't recognize the 12-hour grace period for storage fee.
But actually,
I'm sorry. Yeah.
well, actually, if I can, if you don't mind, in 2014, when this board established a maximum fee, which is in your minutes by Councilman Curran, the maximum set at that time through this board in 2014 through the minutes was a maximum of $350. State law allows you to set your rates. State law also says that the normal fee normally charged, to which Councilman Dorsey had the Attorney General do his opinion as of, I think, 2 years ago or 3 years ago. In that opinion, he said that the towing fee, because the city breaks theirs down into 3 different fees, they have the first 48 hours, they have an administration, which is your processing fee, and then they have the tow fee, which is either 130 or 140, based on the 2009 contract. The latest proposal that was put out, that tow fee would have been $195, just putting it out there. So with that being said, though, the Attorney General said that the admin fee and the storage fee, it is normally charged, but it doesn't mean for the intent wasn't for that to be double. So if you took it upon the rates that are ordinarily charged by the city, and I think we had this discussion before, it would actually be $370 with no storage charged for 48 hours, which meets that guideline of 12 hours. When we did this in 2014, we used to do itemized. That itemization was taken out by Councilman Curran and the tow board. Nowhere in the rules and regulation, which under 22-3C, those rules and regulations have the same force and effect as law. So I understand that there's a need for consumer protections, even though a violator under circuit court, they do not meet the consumer. They're not a consumer. They're in violation when they get towed. But we, over the years, have put a lot of protections in for the consumers because of the nature of our business. But I'm not understanding why these applications aren't being accepted, because these fees have already been established prior to this board, which would have the effect. And if you were going to make changes or not denying, you're extending, I feel that there should have been a hearing between the board and the towers. I understand the law department's in it, and I understand they got the final say, but the intent and what has happened over the 30 plus years that this board has been doing a great job, I think there should have been more input put instead of just looking at the print. That's all. Thank you.
Well, the intention is to ensure that we're in compliance, but I know we have Mr. Salzberg is on the call as well. I don't know if he would like to chime in and provide some clarifications to some of your statements. But you're welcome to, Mr. Salzberg.
Yeah, absolutely. Thank you, Mr. Braxton. So this is Stephen Salisbury, Deputy City Solicitor from the Law Department, and I've been responding and helping to advise Mr. Braxton on some of these questions. We worked very hard to kind of draw a line between what the law department is weighing in on is actually, not consistent with the law, and then also sort of what's more in the tow board's discretion. There are a couple of very clear issues just with the underlying form. The first one, setting aside everything that Mr. Parrish just shared, is one clarification on the storage fees, because the form says, how much you're charging for the first, I think it was first 48 hours of storage. And the city code in the section for trespass towing in Article 15, Section 22, makes very clear that you cannot charge for the first 12 hours of storage. Now that's, again, I think as Mr. Braxton said, that's not on the tow companies, that's on the form itself. I think just needs to be fixed. Because if you put on there that you're going to charge $50 for the first 48 hours, the pretty clearly implied behind that is that you'd be charging for the first 12 hours, which is very clearly not allowed under the city code. So just right out of the gate, that's very black and white, needs to be changed. I think your question, Mr. Parrish, you're sort of the underlying tow fee. I'm very familiar with the AG opinion that came out a couple of years ago on this. The AG's opinion is really just focuses on what gets doubled when there's a reference in state law to doubling of what the local jurisdiction charges. And that's how you get to the 280, because the maximum amount authorized under the city's impound towing is 140. Now, there's some question about whether it should be 130 or 140 under the AG opinion, but it was probably just to be cleaner and out of an abundance of caution. I think the board had this has always been kind of considered as 140 as the underlying cost that gets doubled. That's how you get to 280. That's what is the tow fee. The other charges that you reference when you look at and that's the only thing that the AG's opinion dealt with, is what should be doubled when they talk about doubling fees. Do you double storage? Do you double these other things? The other things, and you mentioned, I think 350 or 370, when we look at what an overall cap is, what we're focusing on is the Maryland Transportation Article, which sets a cap of what can overall be charged. And they are the things that are outlined in Maryland Transportation Article Section 21-10A. It's really three things. It's double what is authorized locally. That's the 140 doubled in 280. It's storage fees, which again get kind of described in various parts of the city code, but again, there's no storage fee for the first 12 hours, then $50 for hours 12 to 48, and then 15 per day after that, as set forth in the city code. But the second thing is the storage, and then the third thing is actual notice, the cost of providing notice. And again, there's separate references to why you can't provide notice. You're only allowed to charge for providing notice after the first few days. But that's how we come back to, the cap is really the sum of those three things. It's the tow fee, the storage fee, and the notice fee. And that's all that's described in the Maryland Transportation Article. So that's all I wanted to offer. I mean, again, I think within those caps, the tow board absolutely, like you said, has some discretion, and so we're not here to try to undermine or override that. But we did see, just on the basis of the form that's been used for the past several years, some clear discrepancies with that, and that's where we did want to weigh in when we felt that things are clearly inconsistent with the state and local law.
Thank you. I just wanted to point out, though, if you're doing the authorized, then we're not looking at 140, we're looking at 150 under that 22-9. The vehicle, a vehicle requiring from embankment, ditch, waterway, if you look under towing, maximum charges, no matter how calculated, may not exceed the amount of 150. It's in the same section as the $50 per day storage. My thing, and I'm not questioning nothing you said, Mr. Stephen, the law department was very helpful. There was many, actually they're down in Annapolis now, the ones that worked on this in 2012 when we did this rules and regulation. We had about 4 lawyers in that room from the city. So they were we went over these drafts, I think 3 or 4 times. The big confusion, and I've talked to Mr. Braxton and Mr. Brady before about this, where the confusion is coming in is back in the day. Of course, I'm a little older, but back when the board established this, the intent and the meaning, when they took away the itemization and they took the city charges of the admin fee and the authorized impound fee, that's where they came up with the 350. How we came up to that back then, it came out to 37. It was 370 or 390 when the legal department where you're at, and the towers, Paula was actually in that conversation with Councilman Curran and myself. That's when we grouped it as an impound fee, because we're not charging a towing fee. We're charging an impound fee, which is an accumulation of the fees of everything we do, because you're not allowed to charge for taping and dollies and all that. It's always been understood that the impound fee was what it took, the maximum we could charge to get it from A to B. So, I just wanted to get that out there. And thank you. How do you put the hand down once you get it up? I was trying to put it down.
Same button. It should lower your hand. Okay. Any further response to that, Mr. Stevens, or should Mr. Salisbury? I'm sorry. Should we?
Yeah, no. The only thing I want to respond to is the 140 versus the 150. And again, this is something that's actually is touched on in the AG's opinion, and that's where authorized is really focusing on what the city is actually charging, as opposed to, I understand Mr. Parrish is correct that the city code does say permit up to 150 to be charged, but because the city actually charges 140 for its impound towing, that's why that becomes the cap. But I didn't have anything further in response to that.
Thank you. Moving on, and this is probably the best segue into our next item of discussion and vote. Number 2, which is the guidelines for the towing fee schedules. So, I would like the board to be able to explicitly outline and limit the fees. Based on the law department's advisement, I propose that the fee schedules to be restricted to a towing fee not to exceed $280, storage fees with the following stipulations: $50 for the first 48 hours following the 12-hour grace period, $15 per subsequent 24-hour period, an administrative fee not to exceed $70 with the following stipulations: must cover the costs of providing notice to vehicle owners, not including labor, covers the costs including postage, MVA fees, court postings, etc. Copies of receipts for costs incurred must be provided at the time of vehicle retrieval, and the administrative fee may be charged 72 hours after the applicant has made vehicle available for retrieval, unless the vehicle owner makes arrangements to retrieve the vehicle. So the board cannot approve fees of $280 for towing and $50 for daily storage to be charged after the first 12 hours. So I'll open the floor to board members to weigh in. Mr. Charles James, I imagine you're still unable to speak.
No comment.
Any thoughts?
I just want to get clarification. So you're saying that the first 12 hours,
Mm-hmm.
they're not allowed to charge you said 270?
I'm sorry. So the first 12 hours, they're not allowed to charge a storage fee or even admin fee. There's a grace period for the vehicle owner to be able to retrieve their vehicles without fees above and beyond the actual tow fee.
Okay, so they would just, if they can do it within the first 12 hours, they will be only responsible for the actual tow.
That's correct.
Okay.
So back to James. Any questions or comments in regards to what I've just mentioned?
Nope, I don't have anything to add.
Okay,
Oh,
glad you're
sorry,
able to.
Mr. Bryson. Mr. Bryson, one more thing. Just a clarification on the 70. You said the $70 was to be added only if what again?
Yeah, so that's the administrative fee, not to exceed $70, and that covers several things: the actual cost of providing notice to the vehicle owners, um, the postage and the MVA fees,
Okay.
um, and the copies of the receipts that need to be provided at the time of vehicle retrieval.
Okay. Thank you.
All right, Miss Neely, any questions or comments to weigh in?
No, not at this point. I'm fine. Fine with the discussion.
All right, and Mr. Glover.
No, I asked my questions already, so I'm good. Thanks.
Okay. Okay, so that'll just
Mr. Braxton,
yes,
just as
yes,
a
sir.
very quick point of clarification, I wanted to add that the $70 admin fee, that is a cap. It's not a flat $70, and it can be charged 72 hours after the vehicle has been made available for recovery, unless the vehicle owner has made arrangements to pick up the vehicle. The intent of that fee is not to be a flat $70 fee, but rather to cover the cost of notifying vehicle owners that they need to retrieve their vehicle.
Correct. Thank you. I did not mention that was a flat fee. It's a cap. So we're all clear on that.
Yes.
All right. All right. Um, so I like to. I'm sorry. So I guess we should move to vote on this matter. Do I have a second?
You have had a motion first, so we had a motion to move, and then we had to second it.
I'm sorry.
No, you're fine. Just so we know.
I yeah. Like to motion to move vote on the matter.
So
Do
move.
I get a second? So all right. All right. So we're going to go down the line again. Lieutenant Charles James, yay or nay?
Yeah,
I'm sorry, I didn't catch. Did he?
yeah, I second.
Okay. All right. Ms. Neely.
It's fine. Approved.
What's Ms. Neely saying? Is it yes or no?
Approved. Yes. Yes.
Yes. Okay. Yes or no? Okay. Yes. All right. Mr. Glover.
Yes.
All right. The vote passes. Yeah. So, 45-day extension. Schedules be distributed. Yeah. Okay. That vote passes. We're moving on. Any questions or concerns about that issue?
I see we have a question from Mr. Showalter.
Why am I not seeing any hands? Okay, Mr. Showalter.
Mr. Showalter, could you unmute?
I'm up, like, Hello? Is that it? Okay,
Yep.
Yeah,
so,
we can hear you.
okay, so just recapping here. So 280 is the tow. After the first 12 hours is $50 for 48 hours. Then the storage starts after that, right? What about dollies? Is there a fee for dolly in cars, all-wheel drive vehicles? That always was a separate line item of dolly in cars. Because nowadays, every car is all-wheel drive and you have to dolly a car. That has always been a separate, because that is a total separate labor fee. Because again, it's a totally different thing to dolly a car versus putting it on a wheel lift and moving it, or put it on a rollback and moving it. So that's totally taken out now.
Yes, those costs are intended to be included within the maximum tow rate of 2 times the 140.
All right, and then the $70 administrative fee does not apply until after 72 hours. Did I hear that correct? I know
Yes,
it's,
just to clarify, that's not an automatic fee that
right.
kicks in after 72 hours. It is a maximum that's intended to cover the cost of, retrieving, vehicle documentation, providing notice to the residents, or I'm sorry, to the owner of the vehicle, court postings. That is supposed to be a reimbursement for the costs incurred doing that. So it's not an automatic fee that kicks in, after the 72 hours.
Okay,
But again, that's only if the owner of the vehicle does not make an attempt to pick their vehicle up within the first 12 hours, correct?
you're saying
Yes.
within 40, but I think you're saying the administrative fee can't come into play until 72 hours, but we're required to send out registered
Right,
letters
right.
to the last known owner, I think after the first 12 hours. We do it
Right. So
immediately
that's what I was referring to, because it seems as if we're waiting 72 hours
to
to be able
notify
to
somebody.
process the 70 bucks. Then what is the purpose of the 12-hour? Like, meaning this individual happened to within 12 hours pick up their vehicle, then the $70 wouldn't really matter at all. It's just a cap, you said, correct?
Right. And Mr. Salisbury raised his hand. So if we want to let him clarify on this question.
Yeah, just one thing. First off, I thought that it was 48 hours based on that you could not charge the cost of notice until after 48 hours. I know we said you're saying 72, but I'm looking at the transportation article 21-10A 04, and that was 48 hours. But that doesn't, I think there was a separate, Councilman Glover's question just about the storage. What it really is it's $50. You can't charge anything for storage for the first 12 hours. From 12 to 48 is 50, and then it's 15 per day after that.
Mm-hmm.
That's what's in the city code.
Mm-hmm.
But to Mr. Diaz, I think it was your point, unless I'm missing something, and I know there's a lot of different code provisions that touch on this. I thought that the notice provision kicked in after 48 hours, not 72 hours.
Yeah, I believe the 72 hours may be board discretion. If we want to come back to this and make it,
Okay, I got you.
just a base 48 hours, that is,
Understood.
for
So
for the board.
I may have misunderstood. So you're saying, because you can't charge for the notice before 48 hours. If the tow board wanted to give an extra 24 hours for the vehicle owner, then that's within the board's discretion.
Now, just to, clarify everything on this question, are towers required to provide written notice before the 48 hours, 72 hours, do they have to provide written notice before the admin fee is assessed?
Well, what I'm saying here is that so the law is 48 hours, right? It's not 72. The law is 48 hours, and it's up to the board to our discretion if we want to go to an additional day, an additional 24 hours, correct?
Right. The law is no less than 48 hours.
Yeah. So the law is 48 hours, and okay. So at the 48 hours, then the company um has a discretion of with the $70 like fee, correct? Because the law states that in 48 hours, as opposed to Mr. Diaz, you're saying 72 hours, but the law requires 48 hours. And it will be up to the tower's discretion, I believe, if they want to add on the additional, uh, you know, time to add up to the 72 hours and not, I don't think it believes it be us as the board. The law already states at 48 hours.
It's my understanding that the board can set um, any time requirement that is at minimum 48 hours. So if the board wants to, revise the motion and say, move that it be 48 hours instead, the fee schedules will reflect that instead of the 72 hours. But I mean, again, just to clarify, are towers required to give written notice before that period?
Mm-hmm.
If I may, in 2012, when the state law task force finished and 2110A was rewritten and then the rules and regulations in Baltimore City, by the third day, we don't close, so we don't have business days. We're open every day. So by the third day, which was 72 hours, we have to send out at that time by certified mail and registered mail to each the lien holder, the registered owner, and insurance if known. The board at that time, when they established 350 as a maximum, they established because state law says actual itemized doesn't have a cap. It has actual itemized cost to get those mailings and to find out who it was. At that time, the city board, the tow board, established the 72 hours to match the 3 days. That's where the admin fee came in. As the years have gone on, when we've submitted our applications, we addressed it as an admin, and some of us, I'm pretty sure all of us, when I've heard the bids, did put in a maximum price that we would charge, but we also had to submit an itemized form with our application to show why we were charging that fee. So I know like Tommy might have had one price, Coop had another price, I had another price for that admin fee. So just to make it clear on that, it's always been 48 hours. But we matched it to match when we as towers are required on that third business day to send those notifications out. Now, over the last 2 years, and I got another bill in this year, we're able to do electronic for registered owners. I mean, for the electronic registered owner is actually the bill I got in with Delegate Foley this year. Hopefully that'll pass. MBA's on board. But last year we got the insurance company if they agreed to accept electronic. And we also, 2 years ago, we got the lien holders. Nationwide, there's only like 250 some. So a lot of lien holders don't do it electronically. But just so you all know, there has been changes. Thank you.
All right,
you for
thank you
that.
for that context. And just looking at the tow regulations, the current tow regulations, point 5.19 does say, to your point, that the owner of a vehicle has to be notified within 3 days. Um, and that the licensee has to provide an itemized list of the costs associated with providing notice. So with that in mind, the board could consider lowering the minimum amount of time before an admin fee is charged, or increasing the amount of time that a tower has to notify the vehicle owner, or a combination of both, so that there's a window of time before the admin fee can be issued, and the deadline that the tower has to notify vehicle owners.
And this is and the time begins after the vehicle is available for retrieval.
Correct.
If I,
Then there's
Mr. Braxton, if I can just say one more thing, if you don't mind. In 2012, we had 5 in-person meetings, law department, the board, and all the licensed towers. And we redid these rules and regulations. This board is missing 3 important components: the property management, the towers, and the citizen at large. I understand you all got a great job to do, and you're all doing a great job. But I would really wish, before we keep doing these motions and the board's agreeing, that we either have a meeting with all those involved with this, and at least have representation on this board. I mean, you're taking our costs back down to 2008, to be honest. And as everybody feels it, a simple truck, a 77,000 tow truck in 2018 just cost me $126,000 for light duty. The insurances are 25% up. And Baltimore City, we've already had 1 national company. We're down to 2. One of the national companies won't even insure us because they're saying Baltimore's so bad. I don't agree with it. But, our industry is taking a hit nationally besides locally. And I just want to put it on the record. I wish this board would at least allow to fill those 3 positions, extend it longer. If you want to redo the rules and regulations, I have no problem with that at all. We've been screaming for that for 3 years. But I really wish we could all get together with all parties involved so that we can do this fairly and reasonably. That's all.
understood, and that will be considered. It hasn't been for lack of trying, to fill the board and all its members. But with new administration, we need to be considerate of that as well. And hopefully, soon after we'll be able to fill all those positions and have all those additional considerations from their perspective. So I appreciate the comment. Any other questions or concerns about this item?
Hello.
Yes,
This is, can you guys hear me? This is Malik Universal Towing.
we hear you.
My question, I guess, and maybe my competitors understand. Um, what does that mean when you say vehicle owner has made arrangements to pick up their vehicle? I don't know what that means. So let's say we tow a vehicle today. It's Monday, and what? Let's say they pick it up Thursday. I can't charge them the $70 if they call me and say I'm coming to pick it up Friday, even though I have sent them letters in the first 48 hours.
I'm sorry. Can you state that circumstance again? One more time,
Let,
just so I'm clear.
let's say we tow a vehicle. Let's say we tow a vehicle today. We have it until Wednesday. We send out the first notice to them on Wednesday. So we've already had the vehicle for 48 hours, almost 72 hours. So if that person comes or calls and says, "Hey, I'm coming to pick up my car when I get paid Friday," are we not able to charge the $70 administration fee, even though we've already went through the process of sending out the letters?
So to very quickly clarify, the $70 is not a flat fee. That is the maximum that a tower can try to be reimbursed for after providing notice to the vehicle owner. So if the whole process of sending the letters, um, getting documentation from the MVA, if that is $30, the tower will charge $30. If the total cost is $50, they will charge $50. But the $70 is a cap. So if it's $100 cost to send out all the mail, retrieve documentation from MVA, do board postings, all of those different charges, they will not be able to be reimbursed for more than $70.
But to answer your question, you would be able to charge that customer.
Okay, well, because I was just wondering, because there was a piece that was put in there about only if the person hasn't made arrangements to pick it up. That's the part I was trying to focus on. Because they said it, you said it 3 times. They said, the $70 could be charged. It's not a cap. I mean, it is capped. It can be charged, but only if the person hasn't made separate arrangements to pick it up. The last part is what I didn't understand. That's why I was saying if they said they wanted to pick it up Friday, could we still charge the $70 because technically they have made the arrangements to pick up the vehicle?
The rationale behind the maximum admin fee is if the vehicle owner arranges to pick up the vehicle, if they call and they are aware that the vehicle is in the tow yard,
Okay.
they don't need to be notified because they're already aware that the vehicle is there. So none of the steps associated with notifying them would have to be taken, and that cost would not be incurred in the first place. So reimbursement would not have to be provided. And, based on Mr. Parrish's concerns, um, they have to notify within the first 72 hours, but the admin fee can't be charged until after 72 hours. Um, the board should consider bringing that back down to 48 hours. So the tower notifies essentially 2 days after the vehicle is made available for retrieval. Um, and during that day, they can notify and they can incur the cost that they will then be reimbursed for.
Mr.
I
Diaz,
guess
I
I'll
don't
say,
mean to,
okay,
Mr.
go ahead.
Diaz, I don't mean to disagree with you, but state law says we shall notify. And
Yeah.
the court cases I've been to, mainly with insurance companies, because they want to say they didn't get the letter in time. But it says we shall. If somebody calls me today and says I'll be up tomorrow to get my car, and it's happened several times, come that third day, fourth day, if they're not here, I have to mail those letters, whether they've made arrangements or not. Just want to put that out there.
However, if they make arrangements to pick up the car before you actually incur costs for notifying them, there won't be any need to reimburse for any costs. Correct?
Yes, if they pick it up before that 72-hour deadline, then no, I don't charge them. But once that 72-hour mark hits, whether they called me or not and said they were coming, I have to put a stamp and I have to send that certified mail.
So being cognizant of your concerns and understanding that there may be insurance implications or other reasons why notice has to be provided, whether or not the vehicle owner is planning to retrieve their vehicle. Um, are you suggesting that there might need to be, for example, a deadline by if the vehicle owner doesn't pick up the vehicle by this time, regardless of intention, the notice will have to be sent?
The state law tells us we have to do it by the 3rd, no later than the 7th. It also helps, we also have to do it in order in case they never do show, in order to get our CS 78s to dispose of the vehicles. So that paper trail is needed. But if people don't normally, and I can speak for my company, normally if they're not here by that 3rd day, they're going to be 4, 5, 6, 7, 8 days out. and I have to mail that letter. I have to protect the company.
Understood. So with that in mind, just kind of parsing the discussion for, the board's consideration, maybe a 5-day deadline, after which, regardless of whether the vehicle owner is aware, the admin fee will be incurred. The company will access MVA records. They will send out the notice. Um, so if after that 5-day period, the vehicle has not been retrieved, that admin fee can be used and the company will send notification. Is that something that, respecting the 7-day deadline by the state would be workable?
If you're asking me, the 3-day works for me because I want this car off my lot. I'm not in the habit of storing cars. We're to tell them, hopefully they get redeemed and they're gone. But the longer my process in order to get that CS 78 in case they don't come, the 72-hour state law is what, we worked on to get it. If they don't come within them first 3 days, we want to start the paper process. That notification is actually starting the process to dispose of the vehicle to get it out of our custody if they're not going to come. And it's also so that the banks and the insurance companies, by you delaying it, you're only opening up a can of worms for the banks and the finance companies and the insurance companies. They're going to act as if we were trying to build storage up. So just through my experiences in Annapolis when dealing with these. So I'm not looking to push it back. If a person doesn't come by the third day, we're getting the letters ready. And if you want to put a cap at 70, which I'm gonna lie to you is low, I think it should stay as actual itemized like the state law says. But if you want to cap it at 70, the 3 days, I think is what it should be, if you were asking my opinion.
Well, the 72 hours is what we've motioned to or voted on. So the 72 hour stands. As far as the vote now, if there's thoughts of changing, then we'll have to motion and reconsider.
The
But right
72
now,
This is
hours.
this Malik Universal. I just wanted to say something too. Another things like Charlie said for Mr. Perry said for liability is you don't even know the person that's calling you if they're the actual owner of the car, not until they actually reach the lot. So I guess I'm still going back on that statement that I just feel like that could get you in a lot of trouble. Where if you send out a letter and they come that same day or the next day, you can't charge them the $70. But as he said, that is the law. We have to send it out within the first 3 days right now. But you could have the girlfriend calling, you could have somebody who borrowed the car. You don't even know if it's the actual owner of the car. And sometimes we have to let the lien holders know we have the vehicles too.
So
correct.
the notice cannot be sent or an admin fee cannot be assessed for the first 48 hours. And that is just a state law. So with that in mind, the board could consider reducing that from the 72 that was just approved down to 48. And that will be the thing that's reflected in the fee schedules. But for those 48 hours, an admin fee cannot be assessed either way. So if it's required that they're notified within the first 3 days, that will still be for the first 2 days. A fee cannot be assessed. And just regarding the item of the vehicle owner making arrangements to pick up their vehicle, that is based on what other jurisdictions have done. We did research on, best practices across the state, and we found that was something that was very, very typically accepted. But if that is a concern, the board could reconsider and the board could create a different standard.
I think it
Okay.
does open for liabilities. Because it's only relevant if the person actually does come and get their vehicle.
Mm-hmm.
That may or may not happen. So, we'll shore up our processes. It'll be reflected in the new scheduling fee.
Can we, I know we're having a discussion back and forth in reference to the 48 and the 72 hours. I know we just voted the 72 hours. Can we revisit this after this meeting? Can we set an additional meeting up to revisit this conversation? Because I want to research some things prior to these conversations that we're having. I think Malik made some valuable points. I listened to some things that Mr. Parrish has said, and I think I would like to, because we already voted on something, and I would like to still revisit this portion of the 48 and 72 hours, only because of the fact we already voted on the 72 hours, but we can revisit this again.
Well, I think what we voted on is the 72 hours, which is conservative. If there's a thought to, scale it back, we can, like you said, revisit it and then perhaps vote again. But I think for the sake of ensuring that we get these applications out, timely and give our applicants the opportunity to resubmit, I would prefer to stay where we are with the 72 hours, and perhaps next meeting we can vote to maybe adjust it if necessary.
Yeah. Mm-hmm.
Awesome.
Mr.
All right.
Schuler have his hand raised.
Hello. I just would like to reiterate, one is I thank you all for being here today. But I really would love the board to reconsider on having a representative from the towing industry such as Mr. Parrish. He's extremely good at what he does. He's willing to work with everybody. So you don't have all of us towers coming at you with different ideas and all. I would, and I know the mayor is the one who appoints towers, tower representation on the tow board. I sat on this tow board for 3 years. I said, so I know what it's like, but I would really ask you all, before any final decisions and any voting is done, please get Mr. Parrish input or one of us towers that are in here today, our input and ideas. So it just isn't one-sided. The industry needs to have input. Mr. Parrish has sat on many boards. He's been in Annapolis. He's part of the TRPM, Towing Recovery Professionals of Maryland. He's also on the Baltimore County Tow Board for towers. I applaud the fact that please bring him in to get a tower's perspective. And I don't think that has been done for a while. The last representation that we had on this board resigned. He got off after me. He was on, I left, he came on, he never even lasted the full term. There's not been representation at that point. And I just think as the towers, again, we should have input of who gets on this board. But I applaud if Mr. Parrish should be the one, he has my vote to sit on this board because he's very knowledgeable about impounding. He runs his own company. He's the one that gets some input from. Thank you.
If I may quickly comment on that, we're working with the mayor's office to prepare a process for onboarding new appointees for the board. We're waiting a updated application, and once that application is prepared, we will, let our regular attendees know so that they can fill it out and, potentially be appointed to go before city council and become members of the board.
Can I say one more thing?
Yes.
And I know the mayor is the big boss. I got it. The mayor appointed a tower that never wanted to sit on this board. He has said that to us when he was appointed, he didn't want to be on that board. So I would think that somewhere down the road, us as the towers should nominate 3 or 4 people, and then they get picked out of their experience and what they do and how they do it, and it should come down as that, my opinion. I don't know if you all have any input on that with the mayor's decision, but I think somebody that wants to be on this tow board should be the one on this tow board to help and not just be, hey, guess what, you're here. And that's what happened at our last representation. And we had missed a bunch of meetings and we didn't know what was going on. There was no input from our representation on the tow board. And we never had nothing to do with him being there. I just think that's something else that if at any possibility, if we could have who we want on the tow board, I think would be a positive thing for you all on the tow board. Thank you.
Yes, you're absolutely right. And this will be an application, so it's not going to be, a nomination made randomly or without input from the nominee. It will be an application where someone will express their interest and then they will be appointed.
Awesome.
Yeah, that's what I wanted. That's what I wanted to add. Only because I know Mr. Tom was just saying that mayor is the big boss to this, and that's just how it works. The mayor gets to appoint an individual to this board as well as the president of the city council. But it will be an application process, and I would encourage that Mr. Parrish to be a part of that application process because you are very knowledgeable of what goes on. You've been in Annapolis, you've been around it for a long amount of time, and I think it helps all of us on the board to make decisions just in a better perspective for the public, as opposed to us just having a phone meeting here and making decisions based on sometimes not even having all the evidence and all the information. We're just going off of what we think. So I think it'll be great, Mr. Parrish. I mean, Mr. Tom is promoting you to go for it, but I think that it'll be right that you do put your name in it. But I do also know the due process to what Mr. Diaz was speaking early on, to find that individual based on the mayor's decision. So, but I do encourage you, Mr. Parrish, to step up and be a part of the board.
And just a couple of other things. Mr. Carroll, did you have any comments? I see that your hand is up.
Yes, sir. It's Robert Carroll with Quick Response Towing. Can you hear me?
Yes, we can hear you.
How you doing, sir? I don't want to hold you guys up. I agree with everything pretty much that everybody, Councilman Glover and all the other towers have said, and we appreciate your time. The thing everybody's feeling the shortcoming is not having a board representative to vote on things, to speak for us, and a property manager that's on the other end of the stick is, sort of giving us we lose every battle. We feel like, we're against, we're already 2 in the hole. We feel like a lot of times on a lot of matters, and the fees, like Mr. Parrish said, and all the other towers know, all of our fees have went up so much that we're going backwards in pricing. And the certified letters, nobody brought it up, but they are $9 and something a piece, almost $10 per letter. Some vehicles have 2 owners, a co-owner and an owner. An insurance company, some of them have 2 lien holders. 5 times, let's say 10, that's $50. Maryland MVA is what, $18 now or whatever? It's almost $20. That's $70. Where's the labor at? Where's the $20 an hour labor for the person doing all this? There's nobody. We're not having meetings to discuss this. We're just saying, hey, $70 cap. But $70 on some of these cars is what it cost us just without labor at all, which is you go to the post office for an hour or 30 minutes to stand in line. With 20 certified letters, they might throw you out the door these days, but that's another issue. But that's, some of these issues you're voting on, we feel like we have zero input at all. And definitely for the towing representative, Mr. Parrish is, what he's saying is all true. And also one other thing, if he's quoting things that happened and we all agreed on, like 350 or this or that or this or that, we feel like it's being discounted. Like we all worked for years and years and years to come up with these things, and now we just open the law book up and say 280. All right, vote, vote, vote. See you later. And it seems like it's not fair to us. And the other thing is we're not getting any consideration for all the work that the other councilmen and board members put in over these years. And also all the fees that we pay come out of our overhead. Whereas if the city, if you make whatever you make a week, a year, an hour, if they say, hey, certified mail went up this week $5, or MVA runs went up, or insurance or vehicles, you won't see your paycheck. You won't see your pay change as the owners of these companies. As soon as they say a tow truck goes up $40,000 and you need 2 of them this year, that's $80,000. So out of your company, and it's no other, we can't get it back because we're capped on all of our fees. That's all I want to say is I feel like, can we please try to have another meeting as a group before the 45-day decision?
I think one of the most important things before we have this meeting is to get this board fully like to the capacity of its needs. Like we don't have anyone from the public on this board. Again, no one representing the towing industry on this board. I think you mentioned about the property management to be on the board. Those are the things that really, really are important when we make these decisions. So I think that one of the best things, one of the best practices for us to use to make sure that we have the board fully active of all aspects before we decide to make these very, very important votes or suggestions.
Agreed, and thanks everyone for their comments. I just want to reiterate that we're not trying to be dismissive or discount the work that's been established by previous administrations. I think our efforts as of late has really been to be definitive about what's clear in the law and make sure that our documentation and our decisions are in alignment with those things. But I do believe that everyone's perspective for the full account of the board would be valuable in determining or voting on items where where the board does have discretion. So I just want to be clear about that. We are looking to make sure that everything that we do currently is in alignment with what the law suggests. And that's been the goal as of recently. But I agree, we will need to fill the board for other discretionary matters.
Mr. Braxton, very quickly.
Yes, sir.
Just based on the conversation and all the concerns raised, seeing as we won't be, able to accept applications for board membership in, next week, couple of weeks, that's still, that timeline is to be determined. Just for now, would the board consider it appropriate, to like resign the decision to make the 72-hour period before admin fees can be assessed, and removing that requirement that the vehicle owner cannot be charged unless they make assessments until we have until we have the rest of the board filled out, and just keeping this to only the essential legal requirement components, the $280 fee maximum, the $50 daily storage after the 12-hour grace period, just with the understanding that a lot of concerns have been raised. Would the board be amenable to considering that?
I'm sorry, Diaz, the 72-hour thing is substantiated by law, right? We were only considering a 48-hour time for our discretion, but the 72 hours we voted on it's already substantiated. Am I correct?
Based on the concerns raised, Mr. Salisbury did specify that it was a 48-hour minimum. So we could lower that back to 48 hours. And, concerns were raised that notice has to be provided within the first 72 hours.
Yeah.
So raising that to 72 could preclude towers from, complying with that requirement while getting reimbursed.
We would have to have a separate meeting for that. We voted on uh, we voted on something earlier, and you're asking us to amend it and re-vote again.
I believe that's what he's suggesting. I'm suggesting that we sustain the vote that we've made, and then it can always be, amended or reconsidered at a later convening of this board.
Understood. I can work with the board members to find a time, next week or two, to reconvene, look a little more into the issue, and present this matter to the board again.
Yeah, I agree. I think we set on the 72 hours, but I think it's important that we take it upon ourselves to have conversations with, the towing industry to have representation before we make many of these moves, because these are moves that we're making to impact the lives of Baltimore City residents. So we definitely need someone from the tow board also to educate us as well. Someone that's honest and someone that's willing to give us the information that's needed, and also with DOT providing those informations as well. And having a law department, we all need to be present to make these decisions, because again, we're affecting the citizens of Baltimore City when we're making these decisions. So I think we made a vote early on. We should stick to the vote we had early on, and come back at another time in reference to how we move this thing forward. But I think we truly need input from the tour industry, because apparently, from what I'm hearing, and even what I'm reading at times during this conversation, that some of us are going over, and we're going beyond even what the law require. And there have been points made from Mr. Parrish, which states, the law says that we need to go in one direction, and we're making, some other decisions based on us as a board. So that's my input on it. I think we should just wait and call another meeting in reference to the vote that we had. But right now, we've already voted on something, and we need to move forward.
Okay. So just considering all the concern, I'll kind of postpone another point of discussion, but for now, are there any other matters of concern for the good of the group?
If I may too, Councilman Glover and Mr. Braxton, just so our meeting, I remember it's been so many meetings, different areas, but in the beginning of the year, I think you put the application out online, and Mr. Liam at that time, and I can't remember his name, he left.
Yeah.
But I did fill out that application. Was it received?
We'll have
I
some.
wouldn't know on my end. Are you talking about from the towing industry? Because if it's something
No,
in reference to the mayor, it would. Are you talking about? Go ahead. I'm
no.
sorry.
I think he's talking about the because the application is available online, and interested parties are welcome to submit their application through the online process. So he's asking, has it been received? And
To fill the vacancy for the representation of the towing.
yeah,
I
I'm not
filled out
sure.
that application earlier this year as asked.
Okay,
I think
we'll
that
confirm.
if it was, I'm quite sure that and it probably has been accepted. I think it could be that there's others that are providing that information to the mayor's office, to the mayor, in reference to that appointment. So it may be, but again, you will have to check probably with the mayor's office in reference to if it was accepted.
That's what I was thinking about.
At minimum, I'll confirm whether that application has been received. And I'll let you know that, Mr. Parrish.
Or if there's been others, Mr. Braxton.
I never even knew there was an application online.
Talk to them.
I never even knew there was an application online for the fill the spots.
Where am I cleaning?
That's funny. That's awesome.
Maybe would you mind placing it in the chat if possible, Mr. Diaz?
When we taking the car
Just a
tomorrow?
link.
We taking the car up to Denny?
Okay, so moving on. Is there any
Come
on public comments before we conclude today's board meeting?
I wanted to get the car washed this morning, but I had to take the truck, Tasha. That's all I'm saying to you.
Mr.
But I came back.
Mr.
You gotta mute your. You guys gotta mute. You guys gotta mute. We
I
have
came right back. I didn't go
conversation.
nowhere. It didn't take me nothing to do what I had to do.
Mr. McLaren, your mic is open.
Damn it.
I have one question that has nothing to do with trespass towing. Does anybody know what the status is for the contract that was awarded to CNS for police towing? And it was granted almost a year ago, and nobody's ever heard anything else about it. Was it 3 years ago, Charlie? Yeah, I was just curious if anybody had any updates on it. I know CNS Towing had won it. The Auto Barn had won the backup to them. And we have asked. I believe CNS Towing's on here somewhere. He actually had, the last meeting we had, they had said, email him. Well, he had emailed it to somebody and they never responded back to where it is on its status of getting awarded. And it's been 3 years.
Yeah, to my knowledge, the medallion contract is still sort of lying in wait. I think there was an emergency procurement that would allow the medallion towers to still operate under the existing contract, but I think we're waiting for a new contract to be let by procurement. Not sure when that will actually happen. I will try to acquire a timeline, but as of now, I think they're still operating under the existing contract.
But I guess my question, I mean, maybe you can't answer it. If the award was already given, then why are we waiting for it to come back out again? A bid? You know what I mean?
Well, there needs to be some new terms within the contract. So you need to re-advertise it to ensure that those things are applicable. And the contract, just the procurement, like laws and regulations require it to be able to be competitively bid. So you have to re-advertise it. It's the same contract has been in effect for too long.
So this is a Rich McLaren from CNS Towing. Let's get, we received a award letter in March of 2024, and which award letters usually mean that there's actually a contract that's been in place. You wouldn't get that award letter until you actually went through a bidding process and you received an award letter and we signed it, but nothing has transpired since March. So what are you saying? We haven't got nothing saying the award got canceled or the bid got.
No, I'm not saying that. And maybe I misspoke. I was under the impression, and then I'll confirm this later and give you the information, but I was under the impression that the current medallion contractors are operating under an emergency extension of the existing contract, which means that at some point they would have to advertise a new contract, and award new members under the competitive bid. So I'm not sure about what award letter you've received, but it could be based on the emergency extension instead of a new advertisement. But again, I'll find some clarification and provide it to you.
If you could, we're under the impression that was an advertised contract, the bid that came out twice now. And the second time we got awarded on March 26th, we have an award letter from the Baltimore City Procurement. I don't know, I think others have been awarded as well. But it said us, said CNS towing, and get clarification from procurement. We're trying to reach out to various police departments. We're trying to figure out what we're going to do and how we're going to do it, how we move forward.
Mr.
Understood.
Braxton, Mr. Braxton,
yeah.
I just want to say one thing that it is a little funny. CNS and myself had gotten penalty letters from the Department of Minority Status stating they wanted us to show them where we had been paying a minority for the contract that was awarded to us, to CNS and myself. I said, we've not even done a tow. CNS definitely hasn't done a tow. He'll tell you they've contacted him 2 or 3 times about you have to show them wagers where you're paying your minority participation. Well, they called here. I had to fill out a letter, and I said, well, I don't know what to fill out because we was awarded the contract. CNS was. I was awarded second. I said, but we've not got anything. So I got into a debate with the Department of, again, the minority status. They said, no, you was awarded it, so you must have been doing work. I said, I've never got a first tow. So it's funny, I had to fill out a form, and on it I put, never received any towing per the award. Chris, if
So
you're on there, CNS, didn't you get the same thing?
Take on, Mr. Paxton, can you just look into it and get back with them
I will.
so we can move further? I mean, that's personal business, you know, with those companies. Can you, you know, find a way to get back to them so we can?
Indeed, this is not a toll board matter. So yes, I will definitely you know, rectify that issue. Sounds to be some miscommunication. Sounds like contract administration is not really aware of what the other you know, divisions or agencies are doing. So I'll provide the clarification.
Mr.
Thank you.
Braxton, just one last thing. Are we staying with our prices, charges, the way we are charging, the way we were approved last year until this next license is approved?
The permit extensions mean that they continue until new permits are approved by the board.
So the pricing that we're charging now, we continue.
Yes, until new permits are either approved or disapproved, which right now will happen 45 days from this meeting or less. The board will be, you know, reconvening on short notice very soon, either this week or next, depending on when members are available, to discuss some of the other outstanding items that were raised in this meeting.
Yeah, I would just add, while the pricing can remain, you know, there was, you know, at an absolute minimum, charging $50 for the first 12 hours is clearly not allowed. And I think, you know, there may be some, you know, ambiguity about the way that the form has been prepared in the past, and that's one of the things we wanted to correct. But even now, that practice shouldn't be happening. So I just wanted to make that clear, even for these remaining 45 days.
Yeah. Okay. So it's understood though, our fee, our impound fee that we put on our license doesn't include, like, my fee is not a storage fee. We're not charging storage until 48 hours later. My
As long as
impound
that's
fee,
as long as that's the case, that's fine.
okay,
It's just nobody should be charging storage for the first 12 hours, regardless of what's already on the last year's applications.
okay.
This does include the first 48 hours that are approved under the current permits. That should not begin until 12 hours have passed from the vehicle made available for recovery.
Okay.
Mr.
All right.
Diaz, at the license that we submitted last year, which was the first year where that additional form was put in, on our applications, we're listing an impound fee. I'm listing an impound fee. And then there was a secondary form that Mr. Braxton sent out to us, which gave a breakdown of, according to city code and state law. What I'm asking is my impound fee that was approved last year, on my receipts, it says impound fee. I can continue charging that, correct, Mr. Braxton?
Whatever the submission is as of now, you know, bought aside from that first 12-hour, you know, grace period for charging storage, will be approved until the resubmission and approval of the new applications. Is everyone clear? All right. This was helpful. It's kind of tough, but necessary. Hearing or seeing no more questions or concerns, I am moving to adjourn this meeting.
See on my side,
So
Brant,
No.
Brant Phillips has his hand up and Bobby Carroll does.
Okay. I'm sorry. I'm not seeing hands on my end.
It looks like Brant Phillips has his hand up. Oh, and Bobby Carroll just took his down. But Brant Phillips has his up. I don't know who that is.
I was going to say, for some reason, it's not showing on our screen. Strange.
Good afternoon. Good afternoon, everybody. My name is Brian Phillips. I'm the owner of BD Towing Service. Just real quick, there's a lot to take in today. So just real quick, I've personally messaged some of the other tow companies. You guys have been in business longer than I have. I just pretty much opened up a year ago. So I just want to reach out to some of you guys. If you guys would take a few minutes out of your busy schedules to reach out to me, or send me a message where I can reach out to you so that I can get more clarification on certain things that some of you older companies have knowledge of. Because, like I said, I'm new to this, but I don't want to fail in doing what I'm doing. So if one of you all would be so kind to reach out to me personally, my number is listed already. So if you guys could just reach out to me so I can get better clarification on some of the subjects that the board raised today, and that way I'm prepared to keep my company afloat. That's all.
We will
Thanks
be
for that.
following up in writing with all of the applicants for the 2025 period. Possibly after the next meeting of the board, which should be happening really soon as all of the board members are available.
And just for
No, we about to go.
clarification, Mr. Bryant, you'll be reaching back out to us about the medallion contract?
Oh, you mean Mr. Braxton? Me?
Braxton, yes.
Yes.
Thank you.
All right. Being respectful of everyone's time, I have to motion to adjourn this meeting. Do I have a second?
second, motion to adjourn. And so 1 second.
I second.
All right. This meeting is adjourned. Thank you.
Thank you,
Happy
everyone.
holidays, everyone.
Happy holidays, everyone.